My guest for tonight is James Kelly. James, welcome. Before I toss to you, I just want to give a little context. I'm an attorney. I am also a litigator. That means I'm in court pretty much every day, sometimes on Saturdays and Sundays, believe it or not. And the cases that I handle, divorce, family court, criminal, I used to be a prosecutor, and civil litigation. So if cameras are allowed in the courtroom, it affects me profoundly. Now, there are exceptions. And with respect to James Kelly, he's a staunch advocate for due process, particularly when it comes to cameras in the courtroom, which are not allowed by the rules of the court. There are exceptions, and I'll get into that. I had a camera in one of my cases recently where there was a sentencing, and the judge gave permission to Newsday. Mm-hmm. But what I'm going to do now is I'm going to toss it to James. He's going to give us an overview, and I'll be asking him questions. I was teasing him. I'm not exactly going to cross-examine him, but I got some questions that I've come to develop, and also other people. When I talk to other people, I talk to people a lot. Good. About cameras in the court. In fact, I was watching Fox News tonight, and they were talking about cameras in the courtroom vis-a-vis the Trump trials. Mm-hmm. So now I'm going to toss it to James. He's going to give the overview. James, I think you should put your seatbelt on, because I think this is going to be a great show, and it'll be very interesting. So take it away.
Thank you very much, Phil. Normally there's a knee-jerk reaction when somebody says cameras in the courtroom that, that's broadcasting. That's a First Amendment right. And you can't do that in the courtroom because it's prohibited by the court, and you'll get arrested. Mm-hmm. No. The argument that it's First Amendment, yes, it is First Amendment, but that's a weak argument. And that's really not where the focus needs to be, despite the fact that almost all of the cases, in fact, I haven't found one that's not a First Amendment case in any of the case law. Well, my approach is completely different. It's a due process right, procedural due process. And by that I mean transcript integrity. The parties before the court have the substantive due process right to a transcript. And of course that means an accurate transcript.
Pay for it, but you're entitled to it.
Right, yes. So they have the right to appeal in certain cases, and that appeal is based on a transcript. Right. And that transcript needs to be certified pursuant to New York State CPLR Section 5525 sub C as accurate within 15 days of receipt. You also have depositions pursuant to New York State CPLR Section 3116 that need to be certified within 60 days. And in depositions, you have the rules of the court, 22 NYC RR Section 206.11, that allow for the recording of the depositions. So with depositions, what you can do is you can take the transcript, right, and an errata sheet that's provided by the reporter that does it, and make any corrections that you might hear that might be incorrect against actual evidence, the actual evidence of a recording. However, the right to settle a transcript is a right. It's a procedural right. And there is nothing in CPLR that says that that prescribes how to settle a transcript before the trier of the facts deliberates on the matters before the court.
I've never had a situation like that. I've had the errata sheet you talk about in the deposition.
Right.
My client fills it out and says, I didn't mean yes, I meant no.
Okay.
Or it's not 60, it's 50. But at a trial, I've never seen somebody challenge the transcript itself that they get from the court reporter.
Well, typically the only time that you would see something like that is in criminal. The jury comes out and the jury asks for the transcript. And of course, at that point, the attorneys have the right to challenge it, to make sure that it's accurate.
But in any case,
as they're
let's
hearing
say it's a divorce. If you're going to appeal,
well, now we're talking civil. Right. And, in an extreme situation in criminal, you can have a reconstruction hearing.
Right.
There's never been any kind of mention of a reconstruction hearing in any kind of civil matter. And yet I know of cases where decisions are made on incorrect transcripts and it's taken as fact and it snowballs and it just goes uncorrected throughout the case.
Let me ask you this. Is it fair to say, and I think we talked a little bit about this before the show, we're getting into some good stuff, that transparency is one of the biggest goals for cameras in the courtroom?
Transparency is certainly a goal. However, transparency can't be the only goal because there are rights that limit that would limit the transparency legitimately. For instance, if you've got a matter of national security,
Right.
then certainly you can't have that broadcast all over the place.
No, we talked about informants, things like that.
Right. You've got things like the Hinton case where you've got an informant, you've got somebody working undercover. There are times to protect these individuals. And there are three separate components to this. There's the recording device itself, which I argue is an arm protected by the Second Amendment. And
The second?
the second, the right to bear arms shall not be infringed. The Second Amendment does not say firearms. It says arms. And the Supreme Court of the United States in the District of Columbia v. Heller, 2008, actually went through a historical discussion of arms. And cameras fit into that discussion quite nicely. Recording devices, as a matter of fact, fit into that quite nicely. So I do take a strong Second Amendment approach.
That's interesting.
On arms. And when I said this on September 12th, not this year, but last year, and we were having a protest outside Central Islip Courthouse, they rolled out the special response team. But so you've got the device itself, you have recording as one activity, and then you have broadcasting. And in between that, you have publishing.
Okay.
Now, I would argue that in all cases, either the party before the court or somebody working on their behalf can record and publish to that party. Now, that's not saying publish beyond that party, that's saying publish to that party. It is quite possible that if there's a challenge in the transcript or the correction to the transcript, that that party could in turn publish to all of the other parties that are present in the courtroom, on the record, etc., so that they could effectively challenge it.
Not necessarily to the media.
Right, to the parties. All right.
That's what I think is a misconception. Because when you say cameras in the courtroom, like you said, that means different things. But that doesn't mean that the Channel 2 News is going to be in there broadcasting everything that's going on.
Absolutely.
That's not what you're saying.
There
might be a place for that, but that's not what you're saying.
There certainly is a place for that. Right. But in general, that cannot be a leading argument. Because, well, if you go back to 1919, I believe it's...
the Black Sox scandal.
No. Schenck v. U.S. or U.S. v. Schenck, I can't remember. It's the one where Oliver Wendell Holmes Jr. opined that you cannot falsely yell fire in a crowded movie theater.
Correct.
And expect the protection of the First Amendment because people could be hurt.
Sure.
So the First Amendment is an important amendment, but it's a fundamental right. It is not an absolute right. Procedural due process is an absolute right. The judges do not have the jurisdiction.
Okay. Make that distinction.
A fundamental right is one that is fundamental. It's in the Constitution. Whereas an absolute right is one where there is no greater public good upon which can be used to impinge upon it. In Carey v. Piffus and in Farrar v. Hobby, the Supreme Court twice opined that procedural due process was an absolute right.
You're talking about the process.
The process.
Okay. See if I can get it on my tablet. Well, that was one of my questions, Jerry. It's a great question, and that's something that I'm going to ask James in a little while. But let me see if I can get these comments.
So now, Angela, we have Gail McDowell saying that this is incorrect, totally incorrect. I would like you to address that.
What's incorrect?
Gail McDowell made a comment. Court reporter in the House here. Yes, there is a settlement of the transcription procedure. You have to apply to the court to do so. But she said it is incorrect. So,
Okay. Meaning something that was said was incorrect? Okay.
Well, I would love to see that in the CPLR because that is not something I've found anywhere in the CPLR. And I know people that have moved the courts
not afraid of cameras, I'm going to give you this.
Okay.
Because this is a lot of good questions here.
Okay.
Gail McDowell.
It's how it is implemented. Protocols are necessary to protect minors or sealed proceedings. And again, that's going to be one of my questions. There are also many discussions that are off the record. Recordings in court need a guardian of the record, a custodian. Ricardo said, if you are not hiding anything and you are doing the correct things, why would you be afraid of being filmed? It's interesting. Gail said, what's incorrect is that he alleges that there's no settlement of the record proceeding. Want to comment on that?
Yeah, I've seen people go as far as providing both transcripts, a transcript of a recording that I've made in a live stream for that particular individual, and the actual transcript for the correction, and the judge ignored it as if it was never properly submitted.
So you're saying there's a process, but whether or not it's adhered to is another story.
Oh, of course. And there is nothing in the CPLR that guides exactly what that process should be. With respect to a guardian of the record and court reporters, just because I'm advocating for cameras in the courtroom does not mean that court reporters are dispensable. They're not. Somebody needs to control people's...
The official record.
Yeah. They don't want people speaking over each other. They want names spelled correctly.
Right.
They want to make sure
That's why it's better than a recording in some cases, because a court reporter can say, look, guys, don't talk at the same time.
Yes.
If no one's there to do that, Gail's not there to do that, then you have people talking over each other. Good luck when it's time to do an appeal, because you're going to have a transcript. You can't. It's garbled.
Well, yes and no. There, depending on what kind of equipment it's recorded on, but yeah, it's something where I am a strong believer that there should be a court reporter there. And court reporters, while we're speaking on court reporters, are experts that are experts because they've taken a test at least one time from multiple speakers for 5 minutes, speaking at 200 words per minute, and made less than 50 mistakes, 50.
Mm-hmm.
So that's a 95% accuracy. And I've got to tell you, Phil, I got to think if I put you on a plane from New York to Honolulu with 95% of the fuel to get there, you wouldn't be happy with me.
I would not. I got an interesting question. Attorney friend of mine, Mike Levitt, he's in family court all the time. Cameras in the courtroom turn the court proceedings into a Kardashian reality show. Otherwise, audio record away. So what would your response be that it's going to turn it into a circus? A camera in that particular courtroom would turn it into a circus.
I think there's going to be a little time for people to get used to things. However, there are cameras in the courtroom now. Because of the COVID pandemic, there's cameras in every courtroom. It's just a matter of who's controlling the record button. All right. And while we're speaking to the record button, there was a case that I remember where there was a camera in the courtroom in another state, and because they focused too much on one particular individual, the judge ended up removing them from the courtroom. So to that, and to the argument that court reporters say, well, we can hear directionality as to where the sound comes from and know who's saying it, as well as read lips. My response to that is that the technology as it is today allows 360-degree recording in video and audio. And to have that kind of camera in the courtroom answers all of those questions, because there's no focus on any one particular person. You've got the directionality of hearing. You want to go back over the record and read lips, you can do that.
I have some questions that I want to go through. What is the common argument? Well, one of them, like Mike Levitt just said, it could turn it into a circus. What is the one argument you hear the most as to why there should not be cameras in the courtroom?
Well, broadcasting is the thing that people go to.
The media.
The media, and then you've got New York State Civil Rights Law Section 52 and what that was created to protect victims from being re-victimized. And there is a very legitimate fear and concern about victims being re-victimized. But the judge has control over broadcasting. While I would say that the judge can't prohibit the recording and the publication to the parties.
The parties.
The parties. Beyond the parties, absolutely.
Parties and their attorneys, of course.
Well, yes, their attorneys as well. But to go beyond that, yes, the judge has latitude. At that point, it's beyond the due process issue and it's into the First Amendment issue. And with respect to New York State Civil Rights Law, Section 52, to protect victims, well, if there's a victim that runs the chance of being re-victimized, it's very simple. You don't allow the broadcasting beyond the parties.
Now, another question I had is, what if, now if both parties are saying, bring a camera in, great. What if one party is opposing a camera being brought into that courtroom? Do they have any standing to keep that camera out?
Does a party have any standing to deprive the procedural due process of another party? No.
Okay. But right now, the rules are you can't bring a camera into the court.
Hold on. You're taking rules. 22 NYC-RR Section 29.1. What would Marbury v. Madison 1803 say about that? That which is repugnant to the Constitution is void and without effect.
Okay. So if you went in tomorrow with a camera, like the old-fashioned big camera that I had when my kids were little.
All right.
To make it out, because a phone, you can't always tell. And you walked in to a judge's part, let's say in a criminal court, and you wanted to record, what would happen?
Well,
and I know you've done this before, so you tell me what's happened.
Well, I walked in with actually an audio recording device at the end of April into a courtroom, and a very large battery, that one. It's about the size of a lunchbox.
I was going to say it's a lunchbox.
And I put it down on the table. I started setting up, and it was on the 9th floor. And
the 9th floor?
Yeah, I made it all the way through the courthouse to the 9th floor into the courtroom.
What courthouse?
And I was setting up on the defense table, or I should say the respondent's table. This would have been Brooklyn.
Oh, okay. We don't have a 9th floor in CI.
330 J Street. No.
Okay.
So I walked into the Honorable Judge Gliedman's part and started setting up. And he didn't say anything, but the other attorneys looked at me in horror, and the courtroom erupted at that point.
Did the attorneys protest?
Of course they did. They did.
Now, what was your connection to that case?
I was asked in.
By a litigant?
By a litigant. I was operating as a recording paralegal for the litigant. The litigant had asked me to do specifically that so that the record could be preserved. That particular litigant had previous cases in that courthouse, maybe not before that particular part, but in that courthouse that used on-the-record recording. Problem is, 3 times it wasn't turned on. And one time it was turned on late. And there was critical information missed on that time it was turned late. So he wanted a backup so that he could validate the record.
And what happened at that particular time?
Well,
were you escorted out?
No, I was not escorted out.
You were allowed to record.
The judge started questioning me under what basis did I have to record, and he brought up Section 29.1, and I cited yes, but there's a carve-out exclusion on 22 NYC RR Section 29.1 sub B. And with permission, I'm certainly able to. But because it's a procedural due process right, you don't need to ask permission for it.
What happened?
Well, we went back and forth, and eventually he read from the computer, and he was reading Section 29.2. I said, no. You're reading too low. You've got to go up. 29.1B. And he's like, oh, okay. And then he ends up reading it. And he decides to disallow it. And he threatens me with the interference of governmental administration, New York State Penal Code Section 19505. And I sat there for a second, thinking to myself, gee, I'd love to take him up on this, because this is not interference with governmental administration.
Oh, gee. Have you ever been arrested, though? Because I want to just...
Oh, sure, twice.
Okay. Have you taken that case to court, to trial?
I'm looking forward to it.
Because that's how it's going to be a test case.
I'm looking forward to it. I have been arrested twice on separate issues. One was thrown out, and the other was contempt of court. And, I walked into court on December 20th, December 23rd, 2020. And I openly told the court officer, you're going to unlawfully arrest me. Here are the charges. Here are the rebuttals against it. And my habeas corpus is downstairs. So before you take the pen off my person downstairs, if you would go to the mailroom and get me my habeas corpus, I'd like to sign it and send it out. They let me record and live stream from the courtroom. The judge ordered me to turn off the phone. I looked at him. I said, that's an unlawful mandate. This was the Honorable John J. Leo.
And before him a lot. I know Judge Leo very well.
Okay, good.
Does divorces. Mostly.
Yes, he does. And he ordered me to turn it off and asked me if it was off. And I said, no, that's an unlawful mandate. I'm going to disregard it.
And?
He ran off the bench and out of the room. And that was that. I left the courtroom after that. And it was rescheduled for February 9th, 2021. And the Office of Court Administration got involved. They created a new policy and procedure that the phone was to be taken off of my person before I entered the courtroom.
The Kelly rule.
Yeah, well, really, that's what it was. And New York State Civil Rights Law Section 52 was posted on the door. So what I did is I read it, posted it way too low for me, but that was probably intentional. I read it anyway and said, yeah, that's inapplicable. And the court officer explained to me the new procedure. And I said, well, so if I understand things right, you're either going to deprive me of my right of access to the court or my Fourth Amendment right for unlawful seizure. So before you do either one of those, I recommend that you go inside and check to see if you're going to be indemnified for this, because I'm going to sit down and fill out a notice of claim and start a federal lawsuit. Unfortunately, I'm going to have to name you as a defendant. So what do you say we meet back here in 5 minutes? He's like, okay. He goes inside to the courtroom. I sit down. I start filling it out. He comes out. He says, go on, right on in, Mr. Kelly.
Now, you said, though, you were arrested twice.
Yes.
Are those pending cases?
No.
Okay, they were dismissed? Or did you take a plea?
One I took a plea on. I was physically present for and followed the no contact order to the letter for my son. My son was having a medically necessary procedure, a circumcision, at the age of 11, and it was something where if you told me I'd be arrested if I showed up tomorrow and it had to be done tomorrow, I'd go in and I'd be arrested.
But shouldn't it be where you get arrested, you take it to trial, and if you lose, you appeal. You know this.
Yeah.
You appeal, and that would be like Brown versus the Board of Education
If
over
I
Plessy versus
knew
Ferguson.
then what I knew now, I would do it differently. But I didn't know then what I know now. As a matter of fact, the no contact order was void because it lacked an expiration date.
Interesting.
And I would have had the whole thing thrown out on that point.
Now, in fact, Danny said, I think a good example is the Johnny Depp case with Amber Heard. You remember that case?
Yep.
Okay. Now, in that case, the camera was pretty close onto the witness. Right? Now, how many cameras should be on a particular case? 1, 2, 3, how many?
I happen to like 2 for the sake of redundancy.
And who are they on?
Well, now you see, that's a great question. When you have a 360-degree camera, they're on everybody. And who controls the view is the viewer.
Interesting. Okay. So it wouldn't be like in the Amber Heard, Johnny Depp case where you only got to see the witness.
No, because
occasionally the judge.
Because to switch back and forth from cameras and to put focus, I understand the arguments. The arguments are valid. But to use a 360-degree video camera eliminates the arguments.
Okay. I got it. Now, very, very important question. I do a lot of divorce and family law. And we have custody cases where the parents beat the heck out of each other. And kids' names are mentioned, where they go to school, sometimes who their teacher is. That could be a big embarrassment. Put the parents aside. A lot of times they cause these problems themselves sometimes. But the child is innocent. So if you have that kind of case, where little Johnny has to go to school the next day. And parents talk, and maybe kids hear parents talk, and next thing you know, they're getting teased, or their privacy is invaded. What do you do about a custody case? Do you have a camera in there?
Well, parents talking, nothing's going to stop that from happening. So the
No, but
embarrassment,
with a camera.
the embarrassment is you're talking about broadcasting.
Okay, but that's my question. So that would only be, let's say, in a custody case, it would be available to the attorneys
Mhm.
and to the litigants.
That's it.
Okay, so it wouldn't be on Channel 12 News at the end of the day.
There might be an appropriate basis for it being on Channel 12 News. Let's say the judge did something absolutely outrageous.
Right.
All right, and that the judge, high crimes, misdemeanors, professional misconduct, et cetera, and due process was deprived. Now, if you're going to do something like that and put a case like that out in public, you will need to necessarily redact to keep the anonymity
Like with a police
of
report.
the parties.
You redact it out.
Right, and
Black marker.
you can blur it, you can change the audio. Same thing with juries. Same thing with witnesses. I mean, if there's something that comes up, there are ways to protect the anonymity so that you have the both the First Amendment protected, and you also have it narrowly tailored. You see, the technology allows you to narrowly tailor in an incredible way, where you can blur out, change voices. You can actually use mechanical devices around the camera to do that as well. And
Those cameras are probably not cheap.
no, those cameras are not cheap. But
How could we afford, let's say, one of those in every single courtroom? Or you're not advocating for that?
well, I think they should be in every courtroom just because you want transcript integrity. However, I also think that in order for them to be in every courtroom and to maintain transcript integrity, it cannot be under the control of the courts. It needs to be under the control of the parties. So that's where someone like me that would walk into court that knows the laws, that knows the ins and outs of, what you can do, what you cannot do, what you ought not do.
So it wouldn't be a civil servant.
No, it would be somebody that would be privately hired, just like you can hire your own court
But there might
reporter.
not be enough money for that.
You're right. There might not be. In some cases, there will be. In some cases, there won't be. And, in some cases, depending on who's doing it, because I can't do them all, it would be somebody, hopefully, that would take a certain amount of pro bono cases.
Well, there would have to be certain, like, look, you just said before there's a certain test for a court reporter.
Yeah.
Right? And you can't just get anybody walking off the street, sit down, and start typing. You might be capable. How do we know if another guy who's walking into that courtroom, unless he's certified or licensed or some kind of assurance that that person has a level of integrity, a level of skill that can do that? There were a lot of, when I first started practicing, when I was an assistant DA, you maybe had 6 district court cases. You got them on the 3rd floor, the 4th floor, the 5th floor, some on the 6th floor. You have Supreme Court. Look how many, you have family court in 2 parts of the county. How are you going to do that?
That's a great question. And it's one that, I'm certainly willing to sit down with the chief administrative judge of the state of New York and hammer out some of the details and some of the requirements where you can say, these are the standards that must be met. If you don't meet them, then you would qualify for imprisonment under these penal codes. I'm perfectly okay with that. I put out a half-hour video and emailed it to him, asking for just that sort of thing. Haven't heard a response.
Now, in fact, Gail had mentioned something about who's going to keep. Normally, you'd have a custodian of the record, like a court reporter has the tapes and everything else, and she's responsible. He's responsible for that. Who's going to keep the video footage? It's a similar situation when all of a sudden body cameras started coming out of nowhere. You have to have a custodian. You have to have chain of custody. Like
You
in a
absolutely
criminal case,
Mm-hmm.
but you're going to want that in a civil case as well, because was it doctored? The second day of trial was lost. How do you do that?
Okay.
How do you protect against that?
Great question. And what that would be is redundant storage and access to redundant storage. These these files would be enormous files if they're done right, because 360-degree cameras and audio generate enormous amounts of data. So it would be something where you'd rent space on a hard drive to store it, and that would be untouched raw data. Upon request, if there was to be broadcasting, then there would be redaction of that for the appropriate protections.
And the judge would decide on the redacting?
Yeah. That would be absolutely within the judge's purview as to whether or not to allow the broadcaster to redact this or to redact that, or however he sees fit or she sees fit.
Now, who is going to pay the fee of the person who comes in, like you said yourself, you could do some of them? Who is going to pay your fee? Because most people aren't going to do it for free. You might, because you might know the litigant, let's say, as a favor. But again, how does that person get paid? We know that the state or the county, I think it's the state, pays the court reporters.
Mm-hmm.
Who's going to pay the videographer?
Well, that would have to be the party.
A lot of times they can't even afford an attorney.
You know, you're right. Sometimes they can, a lot of times they can't. I can't solve that problem.
Mm-hmm. Then you're going to have the situation where rich people might be able to have cameras and poor people might not be.
You know, you're right. That is a valid argument. Now, there's something to be said for doing pro bono every now and again as well. You do 18B work, and
I have in the past.
I'm sure at some point you've done pro bono, too.
I don't get paid a lot, so that's kind of pro bono.
Okay. Well, that's,
but I know what you mean.
That's my point, and that is an appropriate model.
I see. But with attorneys, we have to do certain pro bono or things like that. But for a court reporter, I don't think you're going to find too many court reporters that are going to do pro bono work. They're going to say, this is what I do for a living. I get paid. Some attorneys we do very well, so we could say, hey, you know what? I can afford 5 hours a week doing this particular case.
Right, but it becomes
a videographer.
It becomes an access to justice case, and to have only the wealthy, and to segregate out those that can't afford, that's not right.
Interesting. What about a situation where you have a reluctant witness? Because witnesses are reluctant to begin with. I've had many cases like teachers don't want to come in and testify, where you might have somebody that saw something and they don't want to get involved. I've called, no, I don't want to get involved. Now you tell them they're going to come in and there's going to be a camera, maybe not broadcasted the same way, but there's going to be a camera. That might dissuade some people from saying, heck no, I'm not going anywhere near that courtroom because I don't want people in my community knowing I'm testifying against that bad guy. Let's say it's a drug case.
First of all, that's dealing with broadcasting. Second of all, it's arguing that there aren't already cameras in every courtroom, and as a result of COVID, there are. There are protections for that.
Most of them, more than half, are not even on.
Well, the other half are. And New York State Civil Rights Law Section 52 offers protection for those types of individuals, and it would be the judge's prerogative not to allow broadcasting.
So the judge still has discretion.
On broadcasting, yes, absolutely.
Mm-hmm. And now, when you say broadcasting, you mean, let's say,
beyond the parties.
Beyond the parties. Not just. So what would you call it if it's just for the litigants? It wouldn't be considered broadcast.
That would be publishing to either the party or the parties before the court, and that kind of publishing is part of due process.
Would there be any rules then? So let's say the judge says it's not going to be broadcast on Channel 12 News or Newsday or whatever. But if it goes to the parties get that on a drive or something, a thumb drive. What if they choose? So let's say it's a custody case, and mom is a real you-know-what, or dad's a real you-know-what. And they say, look at that trial went really well, and that my spouse looked really silly on cross-examination. My attorney, Phil Jusino, did such a great job. That litigant publishes it or leaks it, or however you want to call it, to the media. And you know there are media outlets that will certainly pick up on that. TMZ or something like that. They're going to want a name, but that's something that's sexy, salacious. It could happen. What do you do? Sanctions?
Well, let's think of it this way. There was free. What was her name? Britney, Free Britney.
Right. I remember
She
that.
recorded. Now, I almost filed an amicus into that case, but she recorded her own one and released it. And that's very much along the lines of what you're suggesting.
Right.
And that changed the whole direction of that particular case. I think she did the right thing. However, I still think because it's broadcast, the judge has latitude. So the judge can hold her, well.
Well, there could be an order that says don't broadcast it.
Right, but.
And then you'd be violating a court order if you did.
Yes, however, there is the issue where the judge cannot punish for the power of contempt for a true, accurate, and complete description of what occurred in the courtroom. Craig v. Harney, 1947, explains that what transpires in the courtroom is property of the people, the public. So I don't know in New York State that could be punished for. However, it would need to be looked at very closely, and I do think that judges ought to have latitude on broadcasting because, as we said, that's a First Amendment right, and you would build off of Schenck v. U.S., I believe it is, 1919, the one that I mentioned earlier where Oliver Wendell Holmes Jr. opined you cannot falsely yell fire in a crowded movie theater. So it would be, if it harms somebody, then there's a different issue.
Now, we talked about informants. I used to, when I was in the DA's office, I had some drug cases, and they cleared the courtroom when an informant came in. In a case like that, would you just exclude cameras entirely, or would you still have a camera in the courtroom with safeguards?
With safeguards. Because,
Because that guy's life could be in jeopardy.
Absolutely.
If that gets out.
If that gets out, but it needs to be ensured that does not get out. Now, there was a case that made it up to the Supreme Court, and certiorari was denied. Justice Sotomayor opined on it. It was 2018
Fairly recently.
Tawan Towns versus Alabama. And what happened in there is there wasn't an informant case, but there was a recording, there was a transcript, and then there was a second transcript. The two transcripts differed by one word. One said may, the other said must. It was
big difference.
It was in the jury instructions.
I think I heard about that.
And then the recording was lost. And Judge Sotomayor was not happy about that. Not happy at all. But this is exactly the type of situation where having that second recording, and that was a capital case, having that second recording would have made the difference, because then there could have been a reconstruction hearing and it could have been accurate. With respect to the informant, you just need to make sure that it's not published, it's not broadcast.
And if you're the informant, you want to be, wait a minute, what safeguards are in place? Because my life could be worth spit if this gets out.
Well, let me ask you this: since it's a criminal case, if the actual storage device were handed over to the DA
For
safekeeping, you couldn't lose it. But then that would be a protection now, wouldn't it?
Sure. I'd feel much better about that if, let's say, the DA was responsible.
If the DA was responsible. Now, think about Suffolk County.
Because he's not going to want to let it out.
Think about Suffolk County, right?
Right.
We were hacked. We lost.
Oh my God.
We lost how much data?
Sure.
Now, imagine that was all the OTR data that was, or imagine that the OTR data included confidential informants.
Well, that's right. Then
right.
what?
So
the DA could have it, but it was hacked.
So you need to prevent that type of issue. And if it's held physically on a device that's not accessible to the internet after it's done and it's held in a secure place.
Gotta be safeguards, we agree.
Right. Absolutely.
Nothing's foolproof, but you gotta have. I'm just reading some of the comments. A lot of people watching.
Good.
Doreen Quinn, Bob Palmieri, Clark. I'm not sure if he retired yet. Bob, you still there? Gail, I know Mike. He said, Phil always does a great job unless I'm his adversary. I like that. Mike and I go way back. The record, it says, this is what Gail, court reporter, the record is transparent. Court reporters are impartial guardians of the record. The record must be in the hands of impartial guardians.
I have no problem with
And
it
you
being.
agree with that?
I have no problem with it being an impartial guardian. If there's somebody that records in the courtroom on behalf of a party while they're paid by the party, doesn't mean they're partial. They're doing a recording, and if necessary, they make it available to all parties. It's not a different recording for one party as opposed to another party.
No, right.
I'll mention one other thing with respect to court reporters. There was the case of the People v. Sellers, 2021, where it was brought to light that there's a lot of court reporters that actually do record as well as do the stenographic. Yeah. And there was discovery sought on that. Now, it never made it to appeals, but in that particular case, the trial court said, no, those notes are not discoverable. It's the notes of the court reporter. So I didn't particularly think that was a good answer, but okay, fine, that's the answer.
Let's see here. Doreen Quinn Giuliano, you know her?
Maybe not by name, but by face, I'm sure.
See, one thing that I've really enjoyed and learned from this so far, we're not done, but so far, is that you have a perception when you hear cameras in the courtroom.
Mm-hmm.
And then as we talk, I find a lot of common ground. Right? Now, if we kept talking for a while, I might disagree with you here or there, but I think if certain safeguards are in place,
mm-hmm.
and we're not talking about a camera that's going to broadcast to the world, there could be some good in it. I'll give you an example. I've handled a number of appeals in my day.
Mm-hmm.
And I think an appellate court, rather than just getting the black and white of a transcript, sees a camera. Because there are some allegations the judge is not paying attention, or he's biased. Remember that case recently where the well-known Southern attorney was convicted of killing his wife and son? And now there's some allegations that the clerk was looking at the jury in a certain way and saying certain things. The Trump case where the attorney and he are going back at it. Now, we're not seeing it firsthand.
I'll give you a personal example. There was the case of the dishonorable Carol McKenzie, who, in my particular case, as I was reading from the paper...
I've been before her a number of times. I've never had a problem.
Okay.
I'll be honest with you.
As I was reading from a very short piece of paper, 2 minutes worth of reading, she mouthed over the head of the court reporter to the opposing counsel. And fortunately, I had court watchers in the room that caught her. And through the affidavits filed, forced her recusal. But do I think that cameras are good for appellate review? Absolutely. Because a lot of times, judges will do things that are not on the record. In that 2 minute address to the record, there were 5 interruptions. 5. Doors slamming and all sorts of different things. And it's because of things like that. If they have a 360-degree view of the courtroom, and within that 360-degree view of the courtroom, there's actually an area where, okay, this is a dead spot. I can actually have the transcript come up here. They can see the transcript live as it's being said. So they can hear it, they can see it, they can put it on rewind.
Interesting. See, I remember a long time ago when I was an assistant DA, there was a court reporter that took shorthand.
Mm-hmm.
And all of us prosecutors that, let's say, tried a case before him got very nervous because we talked to other court reporters and they said, if this case goes on appeal and that guy dies, we don't know what the heck's on, for the most part. We don't know if we can recreate the record.
There was a very famous case that, and I cannot remember the name, but there was a case years ago where that exact thing happened. And the transcription notes for each particular court reporter, even using the machine instead of Gregor Pittman shorthand, it isn't standard across all of the different court reporters. There's variation, and whether or not they actually ended up with an accurate record, yeah, they're going to try and certify it as accurate, but there's nothing like certifying it against a recording.
Another point is, I think, this is my personal opinion, that if there are cameras in the courtroom, it ups the attorney's game. Because think about it. If you're an attorney and you're going into a courtroom where there's going to be a camera, not that you'd want to look like a fool under any other circumstances, but you're going to be extra careful, I think, to make sure you do everything you can. You don't look the wrong way. You look appropriate. You're respectful to the court. You're at the top of your game because in a sense it's being maybe not broadcast, but everything that's going on in that courtroom is being taken down, not just by a stenographer.
Isn't that a good thing?
I think it's a good thing.
And just think about applying that to judges.
Sure. If it ups the game of the attorneys and judges, that is not a bad thing.
And it keeps the integrity of the transcript.
And I think, like right now, if let's say I had a case tomorrow and there were cameras in the courtroom, right? I may think of it, I'm going to still do my job. But I think if it becomes commonplace, you won't even think about it.
Agreed.
Right? Like you said, you made an interesting point. When COVID hit, we all started doing virtual, right? So there were cameras in the courtroom with a twist, right? So I could see sitting there as an attorney, waiting my turn in some of the courtrooms, because sometimes they bring you in, you're in the virtual waiting room.
Mm-hmm.
Other times I'm sitting there and I'm watching what's going on. Those are cameras in the courtroom.
And do you know that when they closed the courts in New York, the physical buildings, and they created this virtual court system, that they initially kept the public out of those courtrooms? And do you know who the person was that opened up the courts, the virtual courts?
You?
Yep. May 26th, 2020, Champier v. Champier.
What county was that?
That was Nassau. And it was something where Judge Goodstein had to go and reschedule everything, adjourn it, because he needed to confer with the OCA. But after that, the courts were
Office
open.
of Court Administration.
Yep.
For those who don't know.
And then Justina Valva, the next day, reached out to me because she wasn't being allowed into the criminal proceeding of the case as she had been watching. And within an hour,
That's
the mother of Thomas Valva, I had served notice upon all the parties within an hour. And I called up the court. I said, "What's the link?" And Judge Condon's chambers wouldn't give up the link. I said, "Not good." I made one post on Facebook, and there were 95 calls to chambers over the next day and a half, 2 days.
Wait, I got a question. So the link. So the proceeding is going on, and you're saying people outside the courtroom would be able to see what's going on in the courtroom in real time?
Yeah.
But the problem I see is, that if, let's say you're on trial, and you come in and your mom wants to join in, and she wants to sit in the back of the courtroom, and you know what's going to be said? "Ma'am, are you going to be a witness?" And if she says yes, they can't sit in the courtroom. But what if what you're just talking about, a bunch of people can see the proceedings? What if they're potential witnesses?
Well, that was something where judges would actually, ask who people are, which I think is to a certain degree a Fourth Amendment issue. But beyond that, it can be asked, are you or are you not going to be a witness? And if they say, "I'm not going to be a witness," great. Well, certainly their face is recorded. They know who they are. And that can be referred back to.
But if they're outside the courtroom and just get the link, let's say somebody gets a link.
Right. And they're outside the courtroom.
And let's say other people come in to that room.
Right.
How do you monitor that?
The same way you would if somebody physically walked in.
But how does a judge know who's watching that recording or in real time.
Because what they would do is they would have their staff, and typically I think it's the court clerk that does it, but to see who's on and to ask, as they're doing appearances and such, and what's your purpose for being here and such and such. Oh, you're just watching? Great. Or are you going to be a witness? No? Okay, fine.
No, but I'm saying, let's say you said there's the link. So the link goes to someone, Valva, let's say. Okay? And let's say she's at home. Could she watch it at home with the link?
Oh, yeah.
Okay, so she's at home and other people are there. The clerk wouldn't know necessarily who's in her living room,
True,
listening or watching. And it could be, I'm just playing devil's advocate. It could be a potential witness.
it could be. And at that point, when the witness comes in, the attorneys would have to ask,
Right.
On those grounds. And
as an attorney, I'd have to do it's a tougher job because it's easy when I look behind me and I see, okay, I don't see anybody here who's going to be a witness. Or if I'm not sure, I always say, you know what, I'm not sure. I don't want to lose you. Because if the other side is shrewd, they could say something. Oh, that person, Joe, who's sitting in the first row, he said, I'm the greatest parent that ever existed. Now, the other attorney can't call Joe to say, I never said that. Why? Because he just sat in the courtroom. So I always think about that. I always think of the worst case scenario.
And that's a good thing to think about. To be honest, in a trial situation,
I don't want to give too many secrets away.
No, that's an absolutely great point. And I'm never in favor of the virtual courts. I like to see people face to face.
I'm not a fan of virtual courts either.
As a matter of fact, I'm still a fan of paper. I don't like the idea of electronic submissions. The idea of perfect bound is something that I embrace. I want to. It's a lot harder to change or have. There are errors of omission, errors of commission, technical errors that you can't have when you have a physical copy that's stamped.
Another thing, when you make a motion to be relieved, I'm an attorney, I make a motion to get off a case. I don't share my affirmation, the reasons why I'm getting off the case, with the other side. It goes to the court.
Okay.
So I was making a motion to get off a case about a week ago, and I had a devil of a time, and I didn't even get good advice, let's say, from the part or the clerk, because I could say, upload the motion. I said, I can't just upload the motion. Because if I upload the motion, the other attorney and the spouse, if you would be able to see my affirmation. That's a no-no.
And it would prejudice the
case. They said, well, there might be a button. I couldn't find a button. So I had to put an affirmation in to say in chambers, in a sense, in camera. But that was just an example of we have to be careful because if you upload it, everyone involved in that case has access to that document.
Well, you wouldn't upload something ex parte.
But I had to jump through a few hoops just to make sure that I'm protecting my client. They're still my client, that I'm protecting my client's interests.
And that's important.
That's
very important.
And I was sweating it out because I said to my staff, please, whatever you do not upload this. Because I knew the consequences. Let's see. Mike said again, he's not a fan of cameras in the courtroom. Family, it says, someone says, is he ignoring my question? Ricardo. Okay. What was Ricardo's question, if you can find it? He said it was ignored. I don't know. We didn't ignore anything on purpose. Sometimes we miss things. Unfortunately, there were a lot of comments tonight. So I couldn't touch on everyone. So
well, that's fortunately.
Please don't take it personally. And there'll be future shows. So what I do is I go over these questions. So if I bring you on, let's say in a month or two, and you tell me your exploits since you sat here, and I can take a look at these questions. So when you come back, and I thought I had a lot of good questions. I didn't even ask all of them. But
I could go on for hours.
Okay. We have to do a 2-hour show. So, listen, we gotta wrap things up. James? I said I'd call you James. I really want to thank you for coming in.
Thank you for having me.
I got to say, I learned a lot, even though I'm a litigator and I think about this issue often. I did learn a lot. I hope my viewing audience learned a lot. Again, there's no right or wrong answer. People have a right to their opinion. And join us. This show will be on Altice Channel 115 Thursday at 10 a.m. I'm sorry, 10 p.m. 10 p.m. And then it will also at some point go to YouTube and Instagram. I really appreciate all these comments. I appreciate you watching. And that's what makes this show a little interactive.
Mm-hmm.
And I don't take offense. I have very thick skin. So if someone says something that might be insulting to somebody else, I don't care. Right? I believe in free speech.
I do too.
And
And
that's
I'm
why.
going to try and go back through and answer any
Right.
questions if I can.
So we got to wrap up so we can get this show on Altice. It's got to be an hour. So thank you very much. You have a good night and go Jets.